Hello, this is Jamie Sangs. I want to focus on the 10th Amendment to the United States Constitution. The 10th Amendment to the United States Constitution states the following, and I quote, "The powers not delegated to the United States by the Constitution nor prohibited to the states are reserved to the states respectively or to the people." What is the 10th Amendment? I will answer that. The 10th Amendment is about the powers of the federal government, the states, and the people. It is also referred to the privileges of immunities clause, or immunities clause. In other words, the 10th Amendment states that any powers that the Constitution does not give to the United States government belong to the states and the people, excluding powers that the Constitution says the states cannot have. What was the cause and reason for the 10th Amendment? I will answer that. The cause or reason for this addition to the Constitution was to the fear of the founding fathers and framers that the people and the states would be dominated by the powers of the federal government. To ensure the control of this power, the people and the states were granted all the powers that the federal government had not been granted. What does the 10th Amendment mean and why is it important? I will answer that. The 10th Amendment reflects the overall concept of earlier articles. The Articles of Confederation were the first governing document and the original Constitution of America that was adopted on March 1st, 1781, when the last of the original 13 states had agreed and signed the document. The Articles of Confederation contain the terms by which the 13 new states agreed to participate in a centralized form of government, in addition to their self-rule. Each of the states had written their own state constitutions. Under the Articles of Confederation, each of the states retained their sovereignty, freedom, and independence. The Articles of Confederation declared that every state would keep their freedom, independence, jurisdiction rights, and sovereignty. In the government of America, supreme power is retained by the people, not a monarch, and is exercised by representatives elected by them, a constitutional representative government. The government of the United States is referred to as a federal government, a national government in which power is divided between one central and several regional authorities, the individual states. The 10th Amendment made it clear that the federal government had the power specifically granted by the United States Constitution, and that the states and the people also had rights and laws that would be enforced at state level. Court cases, let me give you a few. In terms of jurisdictional interpretations, the courts looked at three major areas in which the 10th Amendment could be violated. First, forced participation. The Supreme Court rarely declares laws unconstitutional for violating the 10th Amendment. In the modern era, the court has done so where the federal government compels the states to enforce federal statutes. For example, in 1992, in New York versus United States, 505 U.S. 144, 1992, the Supreme Court invalidated a portion of a federal law for violating the 10th Amendment. The case challenged a portion of the Low-Level Radioactive Waste Policy Amendments Acts of 1985. The act provided three incentives for states to comply with statutory obligation to provide for the disposal of low-level radioactive waste. The first two incentives were monetary. The third, which was challenged in the case, obliged states to take title to any waste within their borders that was not disposed of prior to January 1st, 1996, and made each state liable for all damages directly related to the waste. The court, in a 6-3 decision, ruled that the imposition of the obligation of the states violated the 10th Amendment. Justice Sandra Day O'Connor wrote that the federal government can encourage the states to adopt certain regulations through the spending power, that is, by attaching the condition to receipt of federal hours, see South Dakota versus Doe, 1987, or through the commercial power by directly preempting state law. However, Congress cannot directly compel states to enforce federal regulations. Here's another example. In 1988, the court again ruled that the Brady Handgun Violence Prevention Act violated the 10th Amendment, Prince v. United States, 1997. The act required state and local law enforcement officials to conduct background checks on persons attempting to purchase handguns. Justice Antonin Scalia, writing for the majority, applied New York versus United States to show that the law violated the 10th Amendment. Since the act forced participation of the state's executive in the actual administration of a federal program, it was unconstitutional. Here's another example. In 2012, in National Federation of Independent Business versus Sebelius, Chief Justice John Roberts, writing for the court, held that the Patient Protection and Affordable Care Act, commonly referred to as ACA Obamacare, improperly coerced the states to expand Medicaid. He classified the ACA's language as coercive because it effectively forced states to join the federal government by conditioning the continued provision of Medicaid funds on states agreeing to materially alter Medicaid eligibility to include all individuals who fell below 130% of the poverty line. Let's go on to the Commerce Clause. In modern times, the Commerce Clause has become one of the most frequently used sources of Congress's power, and thus its interpretation is very important in determining the allowable scope of federal government. Let me give you an example. In Wickett versus Filburn, 1942, in the context of World War II, the court ruled that federal regulation of wheat production could constitutionally be applied to wheat grown for home consumption on a farm. That is, wheat grown to be fed to farm animals or otherwise consumed on the farm. The rationale was that a farmer's growing his own wheat can have a substantial cumulative effect on interstate commerce, because if all farmers were to exceed their production quotas, a substantial amount of wheat would either not be sold on the market or would be bought from other producers. Hence, in the aggregate, if farmers were allowed to consume their own wheat, it would affect the interstate market in wheat. Let me give you another example. In United States versus Lopez, 1995, a federal law mandating a gun-free zone on and around public school campuses was struck down because the Supreme Court ruled there was no clause in the Constitution authorizing it. This was the first modern Supreme Court opinion to limit the government's power under the Commerce Clause. The opinion did not mention the 10th Amendment, and the court's 1985 Garcia opinion remains the control authority on the subject. Most recently, the Commerce Clause was cited in the 2005 decision, Gonzalez versus Rock. In this case, a California woman sued the Drug Enforcement Administration after hermecidal cannabis crop was seized and destroyed by federal agents. Medical cannabis was explicitly made legal under California state law Proposition 215. However, cannabis prohibited at the federal level by the Controlled State Law Substance Act. Even though the woman grew cannabis strictly for her own consumption and never sold any, the Supreme Court stated that growing one's own cannabis affected the interstate market of cannabis. The theory was that the cannabis could enter the stream of interstate commerce even if it clearly wasn't grown for that purpose, and that was unlikely ever to happen. The same reason as the Wickett versus Filburn decision. Let me move on to federal funding. The federal system limits the ability of the federal government to use state governments as instrument of national government, as held in Prince versus United States. However, where Congress or the executive has the power to implement programs or otherwise regulate, there are arguably certain incentives in the national government encouraging states to become the instrument of such national policy rather than to implement a program directly. One incentive is that states' execution of national program place administration in the hands of local officials who are closer to local circumstances. Another incentive is that administration of federal programs at the state level would, in principle, limit the growth of national government. For this reason, Congress often seeks to exercise its powers another way by offering or encouraging states to implement national programs consistent with national minimum standards through a system known as cooperative federalism. One example of the exercise of this device was to condition allocation of federal funding where certain state laws do not conform to federal guidelines. For example, federal education funds may not be accepted without administration of special education programs in compliance with IDEA. Similarly, the nationwide state 55 miles per hour speed limit, 0.08 legal blood alcohol limit, and the nationwide state 21-year drinking age were imposed through this method. The states would lose highway funding if they refuse to pass such laws, though the national speed limit has since been repealed. For example, South Dakota versus Doe. Thank you.